which I know Mr. Franklin's prior counsel seemed to think he needed to repeat repeatedly, thinking that if I repeat a lie enough, Mr. Franklin thinks he can start believing the lies. If we just... Good morning, Your Honor. Kurt Harris on behalf of the plaintiffs.
Good morning, Your Honor. This is Attorney Al Needham for Defendant Del Casal.
And this is Michael Franklin on behalf of myself.
Anybody check? Mr. Franklin, did your counsel check in? I didn't see anybody from the Mueller office. They withdrew, correct?
Yes.
Okay. Want to make sure. All right. I've got multiple motions here pending in front of me. Let's deal with the one that just happens to be right here on top is the motion for summary judgment on behalf of Mr. Harris. Go ahead.
Thank you, Your Honor. I know the matter's been well briefed. There's just a few points that I want to touch on. As you know, this is not the first time the summary judgment motion has been filed, but we don't believe that there are any issues with regard to the amended complaint as it has been pled and based upon the evidence that's been produced and the lack of evidence that's been produced on behalf of the defendants. I would concede on the declaratory relief action. It does appear as though we are covered by a statute, by a stipulation and order at this time, and that's pending, and I guess that's left open at this time. We have moved for summary judgment based upon cause of action number 2, which was theft. There's been no issues of material fact with regard to that. There was a contract. There was supposed to be a sale. A website was supposed to be exchanged. It was never exchanged. Mr. Del Casal had that responsibility. He never complied. He never turned it over. But in addition to that, he utilized that in order to take clients or to redirect lawful traffic of the web over to this website that he and Mr. Franklin set up. Based upon all evidence and information, Mr. Franklin has admitted entirely that he is the publisher, that he has responsibility for it. He has admitted that he drafted some of the content and that he put my picture on the website. Mr. Franklin has admitted to all of the actions that are stated in the amended complaint. He has admitted he did all these voluntarily. He has admitted that that it was wrong, is what he stated in his deposition that he knew at the time, but he continued on with it. And so there should be no issues of material fact with regard to Mr. Franklin, and summary judgment should be entered as against him. Likewise, with the corporate theft, I think that's very similar to the prior pleading that we had. What they did was rather interesting, Your Honor, where they went on the Google web page where you Google the name of a business and then it comes up and there's a box there about how to connect with the website of the business, and he redirected that from my website over to the website which he created, diverting all of my lawful traffic and all of my customers, diverting them away from my business over to his defamatory publication. He stole my clients, or attempted to steal my clients. He worked in conjunction with Mr. Del Casal, we believe, because based upon the information that's been published, only Mr. Del Casal could have that information. There is no other individual that would be in possession of that information. I know that Mr. Del Casal's counsel has raised issues about what ifs, and there are potentials, but we're not dealing with the what ifs or the potentials. They should have done some discovery on that if they wanted to discover it. The fact of the matter is Mr. Del Casal is the only one with that information. All the witnesses are going to testify that it is their belief that he is the author. Mr. Franklin testified he could not exclude him as the author, and their star witness, Mr. Sorosa, testified that he told me and others on many occasions that Mr. Del Casal was in fact the author of this publication. So there's no real question when we look at the preponderance of the evidence that these two entered into a conspiracy between the two of them to make this publication and to try and harm my business and my business practices. In addition to that, quite clear that they intentionally interfered with the business and caused business disparagement. Some of those statements they made, which I know Mr. Franklin's prior counsel seemed to think he needed to repeat repeatedly, thinking that if I repeat a lie enough, Mr. Franklin thinks he can start believing the lies if we just keep saying them over and over. The fact of the matter is they still remain lies, they still remain defamatory, and they still remain untrue. and the statements are about me and my business practices, which would cause harm to anybody who really cares about their reputation. And I feel as though the defendants on this particular case, they don't really understand the importance of reputations. They don't really understand that we as attorneys, it's very important to us, very important to our business practices. And some of us on a moral basis, just it's very important. It means a lot. It means very little to the defendants has been shown, and their efforts are proof of that. The publication is clearly defamatory. I know that Mr. Franklin and his counsel, they went to deep efforts, try and line by line the matter, neglecting the case law entirely, not looking at the case law, not understanding the case law. When we look at slander and defamation, often that can be taken in context. I cited many cases about that. When you talk about people stealing money, when you talk about people depriving, leaving clients on their own, doing bad work, taking their money, extortion, when you use those kinds of words, when you take that in context or you take that individually, those publications are defamatory. They were published to a third party, as Mr. Franklin has admitted. It was out on the web. There's really no question that summary judgment should be granted in that particular on. Your Honor, it's quite clear, I believe, from the as we have pled, that these parties are responsible. They conjured up a phantom, which they rode for a couple of years, stating that some phantom was out there. Mr. Franklin indicated that he's a gang member, that he's a registered member in 3 gangs, and because of that, where he comes from, the streets, he doesn't use last names, he doesn't ask last names, that's part of his street code. Because of that, he couldn't really disclose it because he didn't want to incriminate himself, is what he stated. He understands the law very well. He understands what he did was wrong. He understands he tried to stay anonymous by using a domains by proxy website. He knows it's not a matter of free speech. He knows what he was doing was harmful. He knows what he did was damaging. And under the damages per se law, damages are presumed in this matter, Your Honor. There's really no question of liability in my mind with regard to these 2 plaintiffs. We'd ask the summary judgment issue, Your Honor. Thank you.
Thank you. Okay, who wants to go first? Mr. Franklin, do you want to mention anything that's not mentioned in your opposition that was filed by your counsel?
I really don't have anything that wasn't filed in my opposition. We know that the major defenses of defamation are either truth or a matter of opinion, and we already have testimony that all of the information that was published on the website was either true or a matter of opinion. So we've already had good testimony saying that. So that's basically all I have. There's no defamation because it was true or a matter of opinion. There's several other points that we should file for. I did file a motion for summary judgment, or my attorney did.
Correct.
Go ahead.
No, that's correct. I just wanted to make sure, just on the opposition of Mr. Harris's motion, because we can deal with your motion later, but just on the opposition. So if I understand correctly, your argument in regards to the defamation is our defense is these items are either true or they're a matter of opinion, and therefore they cannot be defamatory, correct?
Correct.
Okay. Anything else in regards to any of the other causes of action?
Yeah, there's a cause of action of, he said something about theft. When he abandoned the website was available. Anybody could purchase the website. So there was no theft on my part. The website was purchased free and clear. Domains by proxy is just whenever you buy a domain name and you want privacy, and which is a standard practice for website developers when they buy a website and they're prepared to hand it over to a client. It goes to domains by proxy.
Okay, thank you.
For
anything else, sir?
Anybody, that's GoDaddy.
Okay. Is there anything else you need to add, sir?
Nope, I believe that's it.
Thank you. Mr. Needham?
Thank you, Your Honor. In regard to the claims of theft, there seems to be two of them. And first of all, I don't think I've ever seen that in a civil claim. So I suppose if we treat it as conversion, I suppose what Mr. Harris is trying to bring. But as Mr. Franklin just said, the domain name, which is the property that Mr. Harris refers to as being stolen, and that was specified in discovery. He specifically said the domain name was stolen. And the domain name obviously expired, as they all do. If you don't keep them up and maintain a domain name, they will expire. And that's what Mr. Harris didn't do. He didn't maintain the domain name. As I understand, he didn't want it anymore. So it became available at some point. Mr. Franklin purchased it. So on that fact itself, there cannot be any theft or conversion. Mr. Franklin, as I understand, still owns the domain name. So, and Mr. Del Casal didn't buy the domain name. The domain name was available and to Mr. Harris, he just didn't pursue it. So I don't know why he would bring a claim of theft in this case under the circumstances of the facts. The website itself, which was built upon the domain name like they all are, that website was on the internet. The web designer's name was right on there, and that information was, Mr. Harris had full and equal access to that information. He simply just didn't want the website, didn't want anything to do with Mr. Del Casal anymore, didn't want anything to do with his organization because it was a men's rights group, and I think Mr. Harris found that to be negative because it was focused on men's rights. So that's my thoughts on theft, and Mr. Franklin himself just explained to the court that he bought it on the internet like anyone could have bought it. So there is no claims of theft. I think those are clearly, summary judgment is appropriate on the claims of theft. And Mr. Harris brought two claims of theft. I guess one under corporate theft, but they're essentially saying the same thing. He was upset that he didn't maintain the domain name and someone later bought it years later. In fact, the contract in this case was entered into March 2014. Mr. Del Casal stayed on the premises for almost 2 years until December 2015. And that's stated right there in Mr. Harris's pleading too, as far as time frame goes. So all this time he's there. And he even described it in his deposition. Mr. Del Casal explained that Mr. Harris didn't want the website, didn't want the domain name. So there is no claims of theft here. I think the court should quickly and forthright dismiss the claims of theft. In regard to, and by the same token, Your Honor, there is no breach of contract. There is no breach. I mean, Mr. Harris had every right to the website, had all rights and access to the domain name, just didn't want it. There's nothing that Mr. Del Casal failed to do. It's like, here's the website, here's the domain name, and Mr. Harris didn't maintain it and let it expire. So there is no breach of contract by Mr. Del Casal in regard to the domain name or the website. In regard to the claims of defamation and disparagement, as the case law says, that's the Clark County School District versus Virtual Education Systems. That's a good case because it's pretty clear on what the elements are, Your Honor, in regard to defamation and disparagement. And both of those claims have an element, an essential element, that publication by a defendant. Publication by defendants. I think it's one of the, it's like the third element. Mr. Del Casal didn't publish this webpage. He didn't publish the webpage, and you have to have publication by a defendant to be potentially be liable for either defamation or disparagement, business disparagement. Mr. Del Casal, therefore, is entitled to summary judgment on the claims of defamation and disparagement. He's not involved in this web page that Mr. Harris sued over. So that's why we filed a separate motion for summary judgment and rightfully request summary judgment on theft, breach of contract, and as I just explained, he's entitled to summary judgment on disparagement and defamation claims. I also
Coun-
addressed
Counsel, isn't the argument that Del Casal had something to do financially with the publishing of it, that he was in concert with Mr. Franklin in regards to the publishing, whether or not he was the active individual who was actually doing the publication? If he is acting in concert with another individual, could he not be liable for defamation if he had something to do with that being published?
Well, I think you were talking about the civil conspiracy claim.
Correct.
In regard, right? Yeah, in regard to this separate and distinct claim of defamation and business disparagement, those are distinct claims. I'm arguing that he cannot be liable. No defendant can be liable for either defamation or disparagement unless that defendant is, by the evidence, has engaged in published that document. If you didn't publish it, you're not liable. Now, in regard to conspiracy, that is an issue, and the court said there may be some issues there that Mr. Harris believes that there was some association of some sort. Mr. Del Casal, it says he had no part in this webpage. In fact, I believe, I'm not sure what hearing it was. I believe it was the last summary judgment hearing in front of Judge Baer, where Mr. Franklin stated in open court to the judge that Mr. Del Casal did not have anything to do with this webpage. Did not have anything to do with the webpage. And I don't have the transcript on that. I don't have the video on that, but I can get it. So right there it goes to the conspiracy claim.
Well, I understand that, counsel, but doesn't that become a question of fact when we have parties who are basically saying the evidence shows this, and your party is saying, no, it shows the opposite? That's my biggest issue in regards to, especially civil conspiracy, is when you talk about publish, and I think you're narrowing it down. If you're saying that only the party who actually types it out and actually sends it is the only publisher, I think that's way too narrow. The individuals who have input on the content, who basically instruct an individual, say, for example, a quick analogy, if I asked my staff to type up something I had written or input that I had gotten, and they publish it, quote, they type it up and send it to the world, are you saying that the creator, the person who basically spoke it and said it to the stenographer, is not the publisher? It's only the person who actually types it up and, quote, puts it on the web, that's the publisher? Or can the person who originates it, has something to do with it, create some of the content, are they not also a publisher?
I think the only thing I don't believe they would be liable for either defamation. They're not the publisher. We can see that. If they're not the publisher, they're not the publisher. And now conspiracy is a different thing.
So if you're going to defame somebody, hire a secretary and have them type it out.
You could be liable for conspiracy to do the underlying matter. Now, okay. I cited a good case, Your Honor, is the Wynn versus Smith.
Yep.
Wynn versus Smith. It's 117 Nevada 6. It's a 2001 case. This is right on point. And Mr. Smith, as we all know, John Smith was a author of a book, and he provided the material. He provided the material to the publisher. And the Supreme Court granted his motion for summary judgment. And he actually provided defamatory material to the publisher. In the case itself, it was actually the material involved whether Mr. Wynn was involved in crime and stuff. So it was pretty negative material.
Right. And the Supreme Court said he gave them material, but he was not the one that told them they should publish it. They did that on their own. They initiated their own publication. They chose whether to publish it or not.
Well, I think
they were an independent body. They were an independent body who retains material all the time, and they decide whether or not it's valid. They didn't do anything to check up on it. That was the argument in Wynn.
Yeah,
that's why.
Actually, yeah, I think the book might have been ultimately published. What it was is a promotional. The publisher took the material and then put their own spin on it in some sort of promotional advertising. And
they altered it.
Right. Well, yeah, they worded it in their own special way. So,
they altered it.
Whatever they communicated out there, that they were sued themselves as well, Mr. Smith and the publisher, and ultimately the publisher was the one that, because they're the ones who published it, and that was, as we see in the case, Mr. Smith got his motion for summary judgment was granted, and he gave the material including some Scotland Yard report. You know, he gave all this stuff to the publishers. I read the case. I read it 3 or 4 times, but then the publisher created some promotional advertising for the book. So literally, you know, and in that case, it didn't look like there was any conspiracy case, but the same arguments were made in that case as Mr. Harris is making now. There was some sort of argument, well, you're the source. You're the source of the material. And our Supreme Court doesn't adopt that analysis of you're the source of the material, therefore you're liable as well. They just don't buy that. The way I read the case, and they specifically address that point.
No, that's what I'm saying, counsel. I think you were hitting it. You were getting the argument. What I was leading to is, if the civil conspiracy, let's just assume for a second that the civil conspiracy is proven, that these 2 individuals conspired to defame this other individual. Once you form a civil conspiracy, and those 2 parties act in concert on that, if one does item A and the other party is part of that conspiracy, as part of the conspiracy, can they be held liable? That's the argument that I think, and that's the only argument really that I'm looking at, is I understand the Wynn case very well, and direct publishing is one thing. But if you are liable under a civil conspiracy, if it's found that you were part of a civil conspiracy, can that concerted effort, the civil conspiracy, that's why it's concerted effort, if it defames another individual, are all parties to the civil conspiracy liable? That's the argument I wanted to address.
And I believe you can, under that scenario, then you can dispose of the and necessarily dispose of the claims of direct claims and distinct claims of defamation and disparagement, but someone could potentially be liable for conspiracy for those claims. I mean, as a standalone claim. But in this case, if the judge feels there's issue in regard to conspiracy, that's one thing. But you can, and that's, you know, but in regard to the distinct claims of disparagement and defamation, I'm arguing that they cannot stand as against Mr. Del Casal because he didn't publish the material, and the Wynn case makes that clear. Now the conspiracy, yeah, you can lasso someone into the underlying, but I don't think you need to continue maintaining those direct claims against any defendant in the case. But we also believe that there's no evidence that Mr. Harris has produced in regard to conspiracy. There's no, I know there's a thing that could be express or tacit agreement is what the language
Just
says.
a passive agreement issue,
right.
Yes.
In this case, but in addition, Mr. Harris hasn't produced any evidence of any agreement or meeting in the minds of Mr. Del Casal and Mr. Harris. I think he has to produce more to show you have to produce something, not just a suspicion or, geez, I think it's Mr. Del Casal. I can see that Mr. Harris does not like Mr. Del Casal. You can see that from the complaint he said. I mean, he doesn't like him, but that's not enough to say, I'm going to make you sue you for conspiracy. And there also has to be evidence of some, tortious conduct by Mr. Del Casal. These are elements, essential elements to civil conspiracy. I just don't see where that exists here, especially on the circumstances where Mr. Franklin has said, yes, I bought the domain name. Yes, I created the web page. And it seems like that under those circumstances, there's no conspiracy here. So that's my argument in regard to conspiracy. I hope, and just to be clear here, Your Honor, as I mentioned from the beginning, I don't believe there's any claims of theft, no breach of contract. I believe the distinct claims of defamation and disparagement must go. Now, a defendant can still potentially be liable under conspiracy, but that doesn't mean you have to continue maintaining claims of the underlying tort against that individual. And that'll conclude I appreciate you considering the argument, Your Honor.
Well, I am. I mean, this case has so many intertwined issues that I want to make sure that I have every input from every single side. And I appreciate, Mr. Franklin, you make an appearance on your own behalf. I appreciate it. A lot of pro ses, when they no longer have attorney, no longer do that. And I wanted to make sure you had all the opportunity to put forth anything that you thought wasn't set forth by your counsel. I wanted to hear it all. Mr. Harris, let's go down the line. Per defendant, theft. Address in reply why I keep both these individuals in here under a theft argument. First, let's argue that one.
Well, with regard to Mr. Del Casal, in the theft and the corporate theft, actually, Your Honor, I know those kind of merged together. Mr. Del Casal never turned over the password to that website. Now, I know that Mr. Needham has argued at length about that, but he never turned over the vital information that he was required to turn over under the contract, and then he converted it for his own personal use with the publication of the website. That's where he stole the property that he sold. It's admitted that he sold it, and it turns up in his buddy's hands. And that's really where, that's pretty much the logical conclusion there that I reach, Your Honor, that he.
Okay, so that would give a basis. That would give a basis against Del Casal. But what about Franklin? Franklin purchased it. Where's the theft on Franklin?
The issue with Franklin is more toward the, think the corporate theft with him redirecting my web traffic over to his website and trying to take my clients, attempting to steal my clients, or utilizing that traffic. I think it's kind of interesting that he just pleads ignorance with regard to his website, but he would be able to go online and find out exactly how much traffic went to that website. We all can. We understand our website. He's supposed to be an administrator. He would know exactly how many views there were and how many people were coming and where they were coming from. He's not disclosed any of that information, Your Honor, and I don't know what he's done with it.
But wait, counsel, again, that's not, you haven't made an argument for theft. This man, Mr. Franklin, purchased a website that was available to purchase, correct?
Correct.
He paid money for it, right, Mr. Harris? He went out and basically purchased a website that was out on the market.
Correct.
Okay, so didn't steal it, paid for it. What you're saying is after the fact, when he had the website that he lawfully purchased, that he somehow should have known that it belonged to somebody else? I'm lost as to how he's still a member of a theft argument.
Okay, exactly. Your Honor, when he went to Google and when he redirected the web traffic from my website to this website, that is when he stole my web traffic. That is when he stole my clients. That is when he stole my inquiries. That's where he did his theft portion of it through the utilization of this property. It's the redirection of my traffic that he went on to change that Google website. He knew that was my website, and he unlawfully represented himself as the owner of my website and of that business, and then he redirected the traffic over to his fraudulent website.
Okay, that gets that. And De La Casal, you said because he didn't give you the password is the theft, right?
Correct. And then utilized it for this conspiratorial activity of trying to defame me.
Okay. So how do I grant an MSJ on that matter for either party when it sounds like we have an issue as to how Mr. Franklin went about diverting this traffic and whether or not diversion of an internet traffic by an alternative site is theft?
Well, I would contend that it's intellectual property, Your Honor, that he's stolen property. He had all the information. He could have disclosed anything he wanted to disclose. He hasn't disclosed anything throughout discovery. He could have turned over the numbers. He could have indicated what was taken or what wasn't taken, who the individuals were, what their web addresses were. He could have done any of that. He did none of it whatsoever. And there's no defense whatsoever for Del Casal. He never turned over the password. He never turned over any of the information. So Mr. Needham used that I should have done this or I should have done that, but without a password, I couldn't have done any of it. And that was required per the contract.
All right. Breach of contract as to each individual defendant. Reply, Mr. Harris.
Only with regard to Mr. Del Casal, Your Honor, not with regard to Mr. Franklin. But that goes right back to what I just stated. He never turned over the password to this website and never enabled me to take full possession of it, thereby breaching.
All right, I got that one. All right. Anything else on the defamation, disparagement in regards to each individual defendant that you didn't speak about?
Just real quick, Your Honor, I wanted to address Mr. Franklin's two arguments about truth and a matter of opinion. He hasn't looked at the case law on that. With regard to truth, He testified at the time of publication. He didn't know anything about me. He didn't know anything. He didn't have any information. He also testified at his deposition, which we have attached to the motion for summary judgment. He had no reason to believe any of it. And so truth is not a defense for him and cannot be raised at this time.
Secondly, let me stop you there. Mr. Harris, let me stop you there. Let's say, just for example, all the statements that were raised in it are truthful, okay? I know you're not going to agree with that, but say they were all truthful. Is there a claim for defamation against Mr. Franklin, even though he said, look, at the time that those things were made, I don't know whether they're truthful or not, but they turn out to be truthful? Isn't the truth still a defense, whether you knew it at the time or not? If it ends up that the statements are truthful, there's no defamation. You haven't defamed anyone because it's truthful. So whether it's truthful at that time or the jury says in trial in 2021 or 2022 or 2023, those were truthful statements, there can't be defamation, can there?
Well, actually, there is, Your Honor. It's at the time of publication that you make that measurement of whether it's defamatory or not. And you raise truth as a defense at the time of the publication, you have to have reason to believe what you're publishing is true, or at least that you believe it to be true. Franklin testified he had no knowledge, he had no information, he had no basis upon which to believe anything was true, but because he talked to people after the fact, he now thinks it's true. I mean, that's essentially what his defense has been. You can't raise it as a defense at that time just because subsequently you learn, well, geez, I dodged a bullet on that one. I guess it was right after all. Now, none of it is true, and Your Honor, I'm not going to agree to it, but obviously you can't raise truth as a defense unless at the time of publication you believe or have some reason to believe it is true.
Okay.
And that's the case.
Anything else, counsel?
Well, second was with the matter of opinion, Your Honor. Matter of opinion is not a blanket immunity. You can't just say as a matter of opinion. This kind of bootstraps with the truth, and I did cite that Times versus Sullivan case and a couple other cases. Very clear on that you just can't say in my opinion. It just doesn't work that way, because every time opinion, you have to show that there is some basis of truth upon which it relies. And so you can't just use blanket defenses with regard to Mr. Franklin as to truth or a matter of opinion. It just doesn't fly in this context. Just one last thing with Mr. Needham. I'm just not sure. I don't know if he just doesn't understand the Wynn case or if he's just misrepresenting it. I actually followed that case in the paper. John L. Smith was a writer in the paper. I was following it when it was ongoing. Mr. Smith declared bankruptcy in that particular case. He gave in. He did fight, but in that particular case, he did not authorize the publication by the paper. He did provide the information, but he didn't give the green light to publish. And I don't think that Mr. Needham understands that. If he said, go ahead and publish this, you absolutely are liable. Just to say that publishers are the only parties that are liable for defamation, that's 100% wrong. The drafter of the information is liable. Your Honor's pointed that out very clearly. Mr. Needham just does not understand that. But everyone, in any context that has anything to do with the publication, can be held liable, particularly the drafter and the publisher. And that would be it, Your Honor. Thank you.
Thank you. Counsels, Mr. Franklin, thank you for your input. I'll have an answer to you by the end of the week. This is one of those ones, counsel, because it is so important in regards to, it's so intertwined between these, especially the civil conspiracy, because that's where I'm going to do my own research on, is civil conspiracy. If in fact a party is bound to a civil conspiracy, for example, if I find that the parties are part of the civil conspiracy, can that body, that civil conspiracy, those units, whoever they are, made up here in this case would be Franklin and Del Casal, if in fact I found that there was a civil conspiracy, are they then liable for the actions committed by each other in furtherance of that conspiracy? That's where my biggest concern is. And the cases that were all cited by all of the counsels don't really go into that. Clearly, like Wynn and all the rest of them, that was not a concern. There wasn't a civil conspiracy being argued in regards to Mr. Smith and the publisher. My concern is that, can a civil conspiracy, if it goes that way, that I find there's a civil conspiracy, can the parties to that conspiracy be held liable for the actions of their co-conspirator to further that conspiracy? That's where the court's leaning. That's what the court's looking at. That's my biggest concern. I'll have an answer to you guys by the end of the week. Thank you.
Thank you, Your Honor.